So thank you everybody for being here tonight for our Crossing Borders training, which is a legal training geared for reporters and artists. We have with us today Nora Benavidez as our guest, calling in from New York. For those of you that are not familiar with California Lawyers for the Arts, we're a statewide organization having offices in Sacramento, San Francisco, Berkeley, Los Angeles, with our newest branch being here in San Diego. My name is Diana Cervera, and I'm the program manager for our San Diego branch. Essentially, California Lawyers for the Arts exists to empower the creative community by providing education, representation, and dispute resolution. And we do that in a number of ways, and I'll mention three quick ones briefly, is education workshops and programs like the one you're attending tonight, our lawyer referral and information services, which is essentially a matchmaking service that connects folks with a legal matter with an attorney that can appropriately address their legal question or issue. And finally, our arts and arbitration mediation services is an alternative form of dispute resolution, which we've been having available since 1980. So without further ado, I'll go ahead and introduce Nora from PEN America. Nora Benavidez is the director of PEN America's U.S. Free Expression Programs, where she guides the organization's national advocacy agenda, working with writers, legislators, and activists to defend press freedom, where journalists are targeted for their work. Nora, thank you so much for being here with us tonight. I'll let you speak more about PEN America's work and yourself, anything else you'd like to share.
Thank you so much, Deanna, and thank you so much to the California Lawyers for the Arts. It's so wonderful to be here virtually with everyone. To get us going, I wanted to just sort of introduce what we do here at PEN America a little bit and what we're going to cover over the course of the presentation this evening. So, I'm the director of our U.S. Free Expression Programs. I actually came to PEN America in 2018 to run our U.S. work, from our First Amendment work to working with journalists to support and protect their press freedom, to sort of monitor emerging threats to free expression around the United States. And before that, I was actually a constitutional law litigator. And so many of the issues we're going to be talking about tonight are really close and very near and dear to my heart. And I'm really, really excited to be here with all of you. So to give you a quick roadmap, there are about 4 things that I would love for us to cover this evening that by the end, I want you to feel empowered to know about. One is we're going to review the legal principles associated with your rights along the border. These are often referred to as the Bill of Rights at the border, and we'll cover those. Those really do include the First, Fourth, and Fifth Amendments. We're also then going to look at ways that you can prepare knowing your rights at the border for when you're getting ready to either cross or for a work trip or otherwise. Third is we're going to go over ways you can then respond if you've been subjected to screenings or to some kind of search. Oftentimes the questions around how do I respond to border agents? Do I give them access to my phone or let them search something? These are the things we're going to go over the course of the training. And then finally, a lot of the work that we cover, it's going to be in extreme detail, so much specificity. And I don't want to overwhelm you. I want to give you as much information as possible, but I also want to give you like the top 5, that by the end, you'll feel really confident that there are 5 things to keep in mind regarding border searches and your rights. So to give you just a little bit of a background and to kick us off, I wanted to highlight the ways that PEN America has worked on these issues to protect free expression for many years. We're an organization that works at the nexus of literature and human rights. And, we were founded actually right after World War II by writers around the world that came together worried about the ways that words and that the written word could perhaps be altered, manipulated, censored. And so writers came together to really defend the written word and defend the freedom to use words at a time when words were manipulated for political and personal reasons. And so to this day, our mission really remains the same: to defend writers, to defend free expression where it may be threatened. And so as some highlights of our work, we recently in 2018 actually sued the president for his retaliation and ongoing retaliation of journalists. In particular, that retaliation is directed only towards reporters that the president dislikes or whose coverage of the administration he dislikes. And so part of why we brought this was because we were so worried about the ways that perhaps our leaders in this country could use and perhaps silence narratives, especially those narratives that may be dissenting. We also then every year celebrate World Press Freedom Day, which is a day of May 3rd. It's coming up. And what we do is we believe that, press freedom, for example, is not an abstract concept, that it's actually a term that really gets back to the fourth estate in this country, that reporters are on the front lines and that they help contribute to communities staying informed, safe, and really engaged in democracy. And so every year what we do is we spotlight what's happening around the country here in the US and why journalists matter. This year it feels particularly relevant to support storytelling and local storytelling in the middle of the COVID pandemic. And so we're spotlighting this year the way reporters are on the front lines, telling stories, keeping all of us informed. But again, this gets back to protecting the ability for people to write and for people to tell stories. And then finally, we're also always advocating for issues at our borders. And this really brings us more recently to the last several years, because a few things have happened while we've been monitoring press freedom threats and other threats that are sort of occurring all the time around state capitals, around our administration. And so part of what we've actually seen is an increase in surveillance and in targeting of dissent at our borders. To give you some numbers, CBP conducted in 2012 about 5,000 digital device searches. That's individuals who are coming and going across our borders. They conducted 5,000. Only 6 years later, that number went up to 33,000. And so that's a 400% increase in just 6 years. At the same time, we are also then seeing other things happening around the United States and at our borders. We know that CBP has a database that contains sensitive and personal information about reporters, human rights lawyers, and others at the border. Last February, a story broke that the LA Times wrote that reporters, human rights lawyers, and other activists were trying to come back from Mexico to the US, and that their passports were flagged and they were prevented from coming back and subject to screenings and detentions. And then a month later, in March of 2019, the NBC San Diego team investigated a story and broke an additional kind of watershed piece that found out that CBP did have this database, that they had over 60 people's sensitive and personal information, all of whom were people that were working somehow on the border. At the same time, we're also seeing a rise in these stops at ports of entry, where individuals are being subject to screenings and questioning simply for coming into the United States. Oftentimes, those are people who are writers, who are journalists, who are trying to cover what's happening in our immigration system and at the border. And then finally, we've been seeing in the middle of all of this, the attempts for reporters to actually cover what's happening around detention centers. Their access has been limited and severely limited at that. Journalists are trying to report on the gross and speculated human rights violations in detention centers, and they're denied access. They're not allowed to interview inmates and individuals who are being detained. They are also not allowed to attend court proceedings in what are called tent courts. And so all of this is the confluence of an ongoing and what seems to be rise in the surveillance, the monitoring, and sort of the chilling of people who are working on the front lines to try to report on issues. So from artists, filmmakers, writers, reporters, all of these individuals, frankly, seem to be now at higher risk of being targeted. And so where are they being targeted? I think it's useful to review what we call the border zone, because that's a lot of what we're going to be talking about tonight, is that there is this perimeter around the United States where individuals are subject to having less constitutional rights than in other places. So compared to the interior of the United States, and this is a really great map that my friends at the ACLU have put together just to show you what it looks like, border agents in the 100-mile border zone have more power and people have less privacy. And so in thinking about, it's great to know your rights, part of what we're doing tonight is going to be covering things like the First Amendment, the Fourth Amendment, the Fifth Amendment, and the 14th Amendment, just a little bit. I also want you to be careful that the things we learned tonight are in no way then indicative of legal advice. And I'll often couch things in that way to try to caution everyone here to be thinking about how you can evaluate your own personal situation given what your circumstances are. Because the area that is 100 miles around the border, that border zone, it really does involve very intensely nuanced and still evolving legal issues. There is no silver bullet that I can give any participants tonight about some of the constitutional issues and to know that there is a surefire answer to what your rights are in certain contexts, because it frankly is still being litigated. Unfortunately, most courts have refused to recognize certain First Amendment as well as other constitutional implications of the digital border searches in particular. And CBP and ICE have policies that over time they have enacted that seek to, in many ways, limit the constitutional rights that we have across our borders. So here's just a brief review for you if you're not intimately familiar with the Bill of Rights at the border. That's an expression that some of our legal colleagues refer to in thinking through, well, how unique, how different are our First Amendment, our Fourth Amendment, our Fifth Amendment rights? How different are they if we're in that 100-mile border zone versus elsewhere? And so really tonight, I want you to come away with a sense of at least where your rights stand in these areas, even if they are still gray and still evolving. What's interesting in many ways is actually that a lot of CBP and ICE policies expressly authorize them and grant them higher authority to do certain things, which we'll walk through today because there's actually ongoing litigation about many of these policies. I'll give you two examples so that you know. CBP, for example, in a 2009 policy authorized Customs and Border Protection agents to be able to examine electronic devices and review and analyze the information that they encounter at the border with or without individualized suspicion, which is a term that we will cover tonight. And really that grants them a very, very wide blanket of authority to be able to do much of what they want. And so one of the questions is, well, why is that? And much of it is because what's thought of in that 100-mile border area is something that is a border exception to the Fourth Amendment, which we'll also cover. But I do want to start with the First Amendment because I think in many ways it's first for a reason. And we'll spend the most time tonight reviewing a lot of the intricacies around the Fourth Amendment. But I do want you to be aware of ways that as the First Amendment, what kinds of rights do you have in thinking about what you can do across the border? We know that the First Amendment is meant to safeguard our 5 fundamental rights, which include speech, assembly, religion, press, and the ability to petition the government for redress. Essentially, when we feel we have somehow been wronged, we also then have that reflexive right to go back to the government and say that we have been wronged. Among those rights, all of those very powerfully protect the right to exercise anonymously our rights to speech and assembly. And so in many contexts, what that means is we have the ability to feel safe in our anonymity, and that the First Amendment would protect that. You know, one of the Supreme Court cases that many lawyers cite back to is from 1995, and a ruling said that anonymity is a shield from the tyranny of the majority. It exemplifies the purpose of the Bill of Rights and of the First Amendment in particular. And it's really intended to be able to protect unpopular individuals from retaliation. And that's much of what we see ongoing in these patterns of retaliation, in which CBP, in which Homeland Security maintains sensitive and personal information about unique individuals. And so when we think about some of the core rights that we all have constitutionally, even at the border, one of those is the right of anonymity. So for example, what does that actually look like in practice? When border officials scrutinize or are looking at sensitive information in our devices, in many ways that can implicate our sense of anonymity, because maybe they're going to go through your inbox and your emails, and what they'll see is who you work for. Well, that is one of the ways that slowly chipping away at your anonymity, you are revealing your identity. or they may go through emails and see sensitive information about other people that then they might seek to monitor. All of these are ways that if border agents are scrutinizing the massive amounts of volume of information in our devices, they're infringing on our First Amendment rights in several ways. First Amendment, I'll lay out just a few more ways. Digital device searches often reveal not only things like email contacts, but also our social media profile handles, even the pseudonyms that we might play with or work under. And so what this does is it allows border agents to match those handles, those social media handles, to your passport or other ID, which effectively unmasks you. It prevents you from being able to speak anonymously online. And it's really true if you comply, for example, with an agent's demands if they ask you to tell them your social media profile names or any others as such. There's also a chilling effect under the First Amendment that if a device search, for example, results in agents being able to look at the institutions that you associate with, like let's say political groups, that will then unearth more associational ties. And one of the things that the First Amendment protects is your basic right to speech and assembly. And under that assembly piece is the ability to associate with others. That private associational ties then, if they are unearthed in instances where agents are reviewing the contents of your phone, those associational ties then could be mapped. They could even be harvested for more professional and personal contacts. And so what's worse is that the investigations could ultimately not just violate your own rights, your own First Amendment rights, but other people's. And then one final thing, since we are doing this in part for journalists, is one way that the First Amendment may be violated at the border is, especially for journalists, is if journalists are required to unlock their devices and those devices contain confidential journalistic sources and work product, that then can inhibit journalists' ability to protect the identity of their sources. So it really undermines the entire news gathering process. Now, under the Fourth Amendment, we're going to spend the most amount of time reviewing this because there are quite a number of intricacies and nuances here, especially where the border is concerned. But point blank, from the outset, the Fourth Amendment is what we call the primary protector of privacy and defends against government intrusion. We know that in most circumstances, the courts over and over again have all agreed that the Fourth Amendment requires that government agents obtain a warrant by generally going before a judge and presenting preliminary evidence of some sort that would establish what's called probable cause. So that it's essentially their belief that something, the thing to be searched or the thing that they want to seize, there is probable cause that the thing they want to look for actually contains evidence of some illegal activity. And they have to obtain that warrant generally before they're allowed to conduct a search. But there are certain exceptions, and we're not going to go through all of them today, but there is one that is crucial for today, which is a border search exception. And that's an exception to this probable cause requirement that officers need to obtain a warrant that shows the probable cause. So the border search exception actually really is advanced on the theory that the government has an interest in protecting what is referred to as the integrity of the border by enforcing immigration and customs laws. So as a result, routine searches, for example, at the border, do not require any specific cause. The government is allowed to conduct a routine search, which does not require a warrant, just because they have this interest in maintaining the integrity of the border and in enforcing immigration and customs laws. And as I had kind of alluded to earlier on, a lot of the policies that CBP and ICE have enacted over the years help bolster their authority in protecting that integrity of the border. So some of those are just the unilateral authority, for example, as I mentioned, for CBP to conduct searches of devices. But slowly, these issues are being litigated in the courts, and the law is beginning to shift. And so one of the hardest things in these trainings when I do them is to tell people that ultimately there is a lot of gray area where the Fourth Amendment is concerned. I think there are some key terms, though, that you should absolutely take away from today. Routine searches, one, do not require a warrant. They also do not require individualized suspicion. And there are two ways that this term is sometimes used. It's either used as individualized suspicion or reasonable suspicion. And courts often use those terms interchangeably. And it's just a really good term, or the set of terms, to know about. Routine searches are not subject to a warrant, probable cause, or reasonable or individualized suspicion. And I keep bringing this home because there are other types of searches that are not considered routine, and that the distinction is really important. But it's also gray. Some, as I highlight here on this slide, some searches are what's called highly intrusive. They impact, for example, the dignity and the privacy interests of individuals, or maybe they are carried out in a particularly offensive way. And yet, there is very little consistency among our courts in the United States, which give us any clarity about what the differences might be between routine and non-routine searches. The distinctions between routine and non-routine searches do not turn on the frequency. So it isn't really about how regularly they are conducting certain types of searches. It is absolutely about the intrusiveness of the search. Thinking about these highly intrusive searches, right, that impact the dignity of individuals. At a minimum, non-routine searches require that border agents have what we call individualized suspicion about a traveler, or reasonable suspicion. And it's really a term that it really supports that a border agent has a factual reason to believe a specific person is involved in criminal activity. But we know it's an incredibly malleable term. So an example, because I think a lot of times the questions I get are always in this section around, well, what about if this happens to me? So if you get stopped coming back, let's say, from Mexico into the United States, is it routine for CBP officers, for Border Patrol, to disassemble a gas tank? It has been considered by the courts that that is considered routine. And it isn't because of just the frequency, how often they do this, but that it's really considered not intrusive, that it is not getting at and somehow violating our sense of dignity when officers disassemble a gas tank. But on the other hand, body and cavity strip searches have often been considered non-routine searches. Those are examples where there is much more need for there to be some level of individualized suspicion that the individual that is about to be strip searched or receiving a cavity search, that individual has engaged in some kind of criminal activity. And again, these are always questions that turn on every set of facts. And so at the end of these trainings, I often have to say, people come up to me and they lay out all of the fact patterns of things that have happened to them. And almost always, it seems that the analysis of what types of situations might need individualized suspicion or not vary regularly. So an example of, I think, a very obvious situation in which individualized suspicion was absolutely necessary, where the strip search, let's say, was not routine, is investigating someone until they defecate all over a room where they're being held. That happened actually in one court case, and these are really horrific stories sometimes of the situations that have happened. That in trying to ascertain whether someone smuggled drugs in their digestive tract, someone was held in a room for hours. Those are incredibly invasive and intrusive searches. And under the Fourth Amendment, in the step before it being even a violation of the Fourth Amendment, the question is, does a border agent have the ability to do that type of search? And that search, that question turns on whether they have reasonable suspicion and whether the search that they conduct then is routine or not routine. And given that digital devices, for example, like smartphones or laptops, contain highly personal information, a big question right now, at least on the digital side, is, are border searches of digital devices routine? And there is honestly still a lot of legal uncertainty here. There are two distinctions in the digital device searches, however, and those are really between manual searches and forensic searches. During manual searches, officers will really review the contents of your phone, your laptop, or otherwise, frankly, the way you would be using your phone. They'll try to play with the keyboard, they'll look at pictures. It's stuff that you can do with your hands, basically. A forensic search, however, is when border officials then use more sophisticated tools. They use software, they use maybe other equipment, and for the most part, when your phone, your laptop, any other digital device gets confiscated, you might want to presume that actually a forensic search would take place. So I think one of the questions is, well, what are the courts saying about these types of searches in particular? And there are two cases that I want to highlight today because they are in very different parts of the country. And they are, I would say, rather optimistic rulings for us in thinking about the ways that courts are now protecting and recognizing that there are Fourth Amendment rights for people who are at ports of entry. So I want to start with US v. Cano. This was a case that was ruled on last summer. And it was in the Ninth Circuit, which covers part of California and other states on the West Coast, which affirmed a case that was called Cotterman with a C. It affirmed this ruling and held that a manual search, so the search that officers do with their own hands, that a manual search of a cell phone requires no reasonable or individualized suspicion, but that a forensic search does require reasonable and individualized suspicion. So again, the question becomes, well, if they're conducting a forensic search, they need to feel there's some individualized reason they want to begin investigating and conducting a forensic scan, whether through software or other tools, to see what you have on the device. In Cotterman, that was a case from 2013 that Cano then significantly lifts up. And I just want to give you a prelude of that case because the Ninth Circuit in that held that the Fourth Amendment requires border agents to have had reasonable suspicion before they conduct the forensic search. And that was honestly a watershed ruling at the time. When this came out, it was in 2013, and it was really kind of ahead of its time. You know, it recognized that a manual search of a laptop was routine, which until then had not been litigated significantly, and that the border search exception applies, which means there is no need for a warrant or any suspicion of wrongdoing for someone to conduct those routine manual searches. In the Cano case from 2019, this past summer, the court recognized that warrantless, so those searches that occur without a warrant and the ones that occur without the reasonable suspicion, are only permissible, and this is the most important part, is that they are only permissible under the Fourth Amendment to determine whether a device contains digital contraband. That is still, I think, really up for us waiting to see how the court and how this case gets applied. But just a few months ago, in November of 2019, a really important district court case came out in Massachusetts, which was, I would say, the most important case in this current type of situation. It was brought by the ACLU, the Electronic Frontier Foundation, and the ACLU of Massachusetts. They filed this lawsuit against Department of Homeland Security and on behalf of 11 travelers, 10 of which were US citizens, and one that was a permanent and lawful resident here in the US. All of these individuals who were plaintiffs had had their smartphones or their laptops searched without warrants at border ports of entry. And so in re-entering the country, whether from business or personal travel, border officials search their devices anywhere from 30 minutes to hours at a time. And so the complaint itself, they brought two things, and two things in particular that will be of use for us. One, the complaint argued that CBP and ICE violate the Fourth Amendment by searching people's devices absent a warrant, supported by probable cause, and that they violate the First Amendment by searching devices that contain our expressive content and what's called our associational information. And that they do that in violation when they do it without a warrant that is supported by probable cause, and without expressing anything particular about why they're engaging in those searches. And the ruling was quite simply pretty amazing. The First Amendment issues were never reached, actually, but the Fourth Amendment issues were. And what the court held is that the government, when it conducts these suspicionless, warrantless searches of people's smartphones and laptops, whether it's at airports or other ports of entry, those searches violate the Fourth Amendment. And it really, one of the most interesting aspects, if you think back to the very beginning of our presentation today, is think back to the numbers of searches that I started with. Remember, in 2012, we saw about 5,000 digital device searches on the part of border agents and CBP. By 2018, do you remember, we saw that number go up 400% to 33,000. In the course of litigation, in the Al-Assad versus McAllenan case, the defendants identified 34 cases where their list of prosecutions resulted from the searches that they conducted of people's devices, which was really trying to substantiate, when they provided those 34 cases, to say that, well, we search these individuals' devices to ascertain if they are committing criminal activity. And we do that to protect the integrity of our borders. And what the court found is that, honestly, the 34 cases that ultimately ended up being prosecuted based on those 33,000 searches, that is just not a robust rate. And so over and over again, it seems like the court seemed to be moving towards finding that the Fourth Amendment was in fact violated when all 11 plaintiffs had their devices searched and seized. So now, at least in the Massachusetts District Court area, border officials must now demonstrate individualized suspicion of contraband before they can search a traveler's device. And there are just a few key things in this ruling that are worth noting. You know, I think one is a cursory search of a device, which means a very brief look reserved to exclusively determining whether a device is owned by the person carrying it across the border. That would fall within the border search exception. And so it would actually not require a heightened showing of cause. So if you're crossing the border and one of the things that happens is just a scan of your device to see if you own it, the ruling from this court in the Massachusetts District Court held that that would not require a heightened showing of cause, that they are allowed to do it with that lower individualized suspicion level. I'll make one point, though, that sort of supports, unfortunately, that many of these issues are still in flux. In 2018, the 11th Circuit, which covers areas in the South around Georgia and Alabama and other states, ruled that a forensic search, which is, if you recall, the type of search that happens when there are more sophisticated tools involved, that a forensic search of electronic devices at the border was okay, even in the absence of a warrant, probable cause, or individualized suspicion. And I bring this up because the victories that are on this slide, the Kano case and the Al-Assad case, they're really exciting. They're promising cases. I absolutely think that the Al-Assad case is going to be appealed by Department of Homeland Security, so we can expect that to be still moving through the courts. But what it really means when we think about the wide range of court rulings we're seeing is that many of these issues, especially the Fourth Amendment issues, and the question of what level of suspicion do officers need to have to investigate and search your devices or otherwise, those are incredibly malleable and they are evolving all the time. Now, in moving towards the Fifth Amendment, this is an interesting area that also is still sort of moving through the courts. The Fifth Amendment guarantees that essentially you cannot self-incriminate. You cannot be a witness against yourself. So statements and actions that qualify as bearing witness are called testimonial. And a person's state of mind, or let's say their statement or action, it's testimonial if it discloses the contents of their mind. So the best way to preserve your Fifth Amendment rights, frankly, given your risk of tolerance for these things, is to usually, in the context of being at the border, politely but firmly decline to comply with various demands around unlocking devices. It's really an area that I think is incredibly hard. And when we think about the issues we each deal with when you're crossing, especially coming back into the United States, if you live in the United States and you're crossing for work, you're crossing for seeing family or otherwise, it's an incredibly stressful situation when you encounter border agents. It's stressful because it's so hard to know how you balance the issues and the interests that you might be facing on any given day. And so one of the things we're going to be moving towards is looking at what the threat assessment is for each of us and how you can think through analyzing what your threat assessment level is. But when you generally think about what the Fifth Amendment rights are that you have at the border, you may think about whether you can decline when an agent asks you to unlock your device. And there are a few different ways. Unlocking your device nowadays looks so different than it did even in 2010. And in 2010, one court held that the Fifth Amendment gives us an absolute right to refuse to provide a password to unlock or decrypt your device. And there was really, it was honestly an amazing ruling in 2012. But we know that now the technology around our phones and the way we unlock our phones has begun to shift, evolve. Now we have facial recognition and we can slide our phones in different ways to open them. We have passcodes that are maybe different, such as our thumbprint. And so honestly, there is still a lot of gray area where the question of what kinds of Fifth Amendment rights do I have? Can I confidently refuse to unlock a device if a border agent asks me? And it really is going to come back to this threat assessment. The act of entering a password or telling a border agent what your password is, at least in 2010 in this one court, they found that that is essentially a form of testimony, that it's bearing witness to yourself or an act of self-incrimination then. It exposes the contents of your mind because it opens up all of the information on your phone. Also, when the data on a device is encrypted, the process of decryption, this court in 2010 ruled, was considered testimonial. So it comprises the kind of translation of evidence that then border agents or other law enforcement have access to, and they can then understand more. So this is a ruling from a single court. It's an incredibly, for me at least, when I think about the kinds of legal tips that I give people, I always caution individuals to say that there is just so much latitude depending on your situation if you feel comfortable pushing back and challenging agents that might request that you open your device. But generally, there is very little ground to stand on to say that the Fifth Amendment is actually violated when that demand is put on you. There is an issue, though, around implicit consent that I think is worth talking about a little bit. Implicit consent is one of the ways that law enforcement may try to get you, in a way, to say yes, to admit and give consent to different searches. And what we know is that in the middle of all of your Fourth Amendment rights, if an officer asks, "Can I look at this? Can I search it?" and you say yes, there is suddenly no need for any kind of probable cause, warrant, individualized suspicion, or anything, because you've given consent for them to engage in whatever activity. So there are ways to be mindful of how you might avoid implicit consent. Law enforcement officials will often try to persuade civilians, to consent to searches. And once you consent, it can be much, much harder to challenge whatever search occurs later in court. So here are some ways, because I feel like we need concrete tips. You can inquire if a border agent does ask you and is trying to maybe get some implicit consent. You can inquire whether agents are asking you or ordering you to do certain things. So for example, if you're stopped and they want to look at your phone and they say, "Well, I'd love for you to unlock it," you can ask, "Are you ordering me to unlock my phone, or are you asking?" You can also inquire whether agents are ordering you to provide your password or ordering you to disclose your social media information, which again gets back to your First Amendment rights, as we talked about earlier in the training. If an agent says that, if you ask that question, and if they respond by saying it's only a request, you can politely then, but firmly, decline to comply with the request. Now, if you do choose to comply with a request or a border agent's order to unlock your device, those are things that implicate a whole other set of issues. And you can inform an agent that you're complying under protest and that you do not consent. If you later then want to assert a legal challenge, this could help you circumvent a claim made by the government that you consented to the search. And in many ways, a lot of this is really building a record of what your experiences are if you do get stopped by border agents. Because those are, as I mentioned, incredibly stressful situations, whether it's being held at a port of entry like an airport and subject to screening there, whether it's subject to secondary screening at other ports of entry or checkpoints, but just be mindful of the ways that you are either potentially electing to comply, or if you're in a position to be able to decline an order and you're able to proceed in declining, there are obviously going to be other consequences. And at this point, border agents are very likely to escalate encounters. We know that border agents seize devices because we know what the numbers look like, that those numbers have continued steadily to go up. Those numbers in 2012, 5,000 searches and seizures. By 2018, 33,000. So if you're feeling emboldened and empowered, the types of things that you need to be prepared for if you do say that an agent cannot search your device is that they may confiscate it. And if they do, there are things that then you need to be mindful of as your next steps. If they cannot decrypt your devices, they may be able to copy encrypted contents. And then later, if agents somehow are able to obtain your passwords, they may be able to decrypt. So there are all sorts of ways to think carefully about the sensitive information, the private information that you have on your devices before you go about crossing. Now, some travelers try to honestly persuade agents to withdraw their demands. Let's say they may object that the information is sensitive, such as attorney-client correspondence or journalistic sources. And sometimes that works. I also think that there are ways that what this does is it just alerts agents more to the individuals that they are encountering. And I do know journalists in particular that I've worked with that have said the agents that I see regularly, they always know who I am. And it's really just a question of if your number is up, it's up. If people are in a certain mood. And it's one of those realities that over the years when I have conducted these constitutional trainings, I so often say there are rights that we do have, and then there are knowing that they may be violated. And this is one of those instances, especially around being searched, questioned by border agents, where there is just going to be limited ways that we can feel empowered to exercise our constitutional rights. So what are the things that you can do? This is, I would say, the second most important slide, perhaps, in the training. One is conduct a threat assessment. So if you're thinking about crossing, whether it is for personal reasons, professional reasons, or otherwise, there are ways that you can think through your identity, your background, your travel history. And I'll walk you through a little bit of what I mean by this. One, if you are someone that crosses regularly and the agents that you encounter often now recognize you, do you have a history of criminal activity? Have you been arrested in the past? Do you have sensitive citizenship status that you're nervous about? Are you known by border agents for your reporting or your documentary filmmaking or your relationships with other people across the border? All of these, even if not fair, are necessarily going to implicate the kinds of ways you evaluate your threat assessment and the likelihood of being targeted. And when I say targeted, what I mean is being someone picked out for a search or for questioning. The other thing you want to think about before you cross and before you begin a project of any kind is, what are your interests in being able to resist privacy violations? And what I mean by that is, depending on your personal circumstances, I have talked to filmmakers, I've talked to reporters, I've talked to artists, and it really depends on where their state is, their state of being and where they are in their station in life. A reporter who has sensitive information in their pack, maybe they are crossing regularly trying to complete a story and the deadline for that story is tomorrow. If an agent wants to then search or question you, you may feel that your identity, your background, your travel history, all of those would support that you really can be empowered and even emboldened to exercise your constitutional rights, but you have a deadline tomorrow and you cannot be held for 12 hours for a secondary screening. Or maybe you have a kid at home and your babysitter is not going to be able to be there for the next 16 hours. And so these are the types of things that, in weighing what are your interests in resisting the types of questions or resisting the violations that may occur, these are the other set of issues to begin thinking about. All of that is the part of conducting your own threat assessment. Another thing is to consider the digital safety issues, and we cannot, because of time, get into too much of the details here, but there are some things that I want to leave you with. One is, decide whether you can maybe reduce before you leave the amount of digital information that you're carrying across the border. So for example, you may want to leave certain devices at home. You may want to use temporary devices. You may consider deleting contents from your devices or shifting content to the cloud. You also want to consider protecting the information that you actually do carry, whether it's, on your cell phone or on another device. You may want to consider doing something like using a full disk encryption and backup data somewhere else. All of this is just to help minimize what you're actually bringing back and forth and minimize the kind of data and the volume of data that you may allow an agent to encounter. So shortly before arriving at the border, generally a lot of the sort of standard thinking is that you want to power off devices. You want to resist a kind of variety of high-tech attacks. At the same time, I do know that people have told me and alerted to me that there are these nuances in which having no devices, perhaps, or having a device that has been wiped clean can actually prompt suspicion and questioning from agents. And so again, a lot of this gets back to how you're conducting your own threat assessment. Either way, minimizing the devices you have when you're crossing, and even sometimes using temporary devices, is incredibly smart. Also keep in mind that forensic searches, we talked a little bit about the manual searches and forensic searches of devices. Keep in mind that forensic examinations, those can actually recover deleted photos sometimes. And so unless you know that you've confidently and securely wiped all of the data from something, you have to be careful about what may be there and what may be gathered in a forensic search. So what about when you're at the actual border? I think a lot of it is first remember what your threat assessment was. Think back to what your analysis was, what risks and timing you're facing. Agents may ask travelers to unlock their devices, to provide information about themselves. And frankly, I sometimes think that no matter what the lines of questioning are, there's really a no-win dilemma. If a traveler complies, then agents may be able to, for example, scrutinize, copy sensitive information and digital data. But if you're declining whatever the orders or the requests are that border agents make, agents can seize those devices. And not only that, but then they can subject people to additional questioning and detention. They can otherwise then escalate the encounter. And there are, again, just because you have certain rights in the end, it does not mean that those rights may not be violated. So you want to think about maintaining a record of knowing what your threat assessment was before you begin your trip, minimizing the amount of data and other sensitive information you have when you're actually crossing, and then thinking about if you feel your rights have been violated. After your trip, how can you maximize remembering everything? Whether it is creating a fresh record by memorializing everything, a narrative of what happened to you. It may provide useful in the end. Make sure you're changing your device passwords if they were confiscated. And then always contact, there are certain organizations like the ACLU, EFF. Those are fantastic resources. Now, I said there was the second most important slide. I think this is the single most important slide for you in understanding some of the nuances here, because these are the top 5 things that I've put together of things for you to keep in mind. These are for all of us. It's for artists, it's for reporters, writers, anyone that is crossing. And to think about, how do I take all of this information over the last hour or so, and how do I actually make sense of it? First of all, agents shouldn't be asking questions that are unrelated to verifying citizenship. They also can't hold you for an extended time without cause, but that doesn't mean they won't do it. So in thinking through number 1, you want to be able to feel like you know that agents cannot hold you for an extended time without cause, which means number 2, always ask if you are free to go. If you are not free to go, you can assume then that you are under arrest. And if you are under arrest, then even by assumption, you have the right to remain silent. And that is an incredibly powerful thing to know. It is really honestly in sort of that worst case scenario category. If you're just stopped, if you're detained, if you're harassed, if those are ways that you still feel comfortable trying to maximize your ability to record the situation or from memory, try to remember who you dealt with, try to get the name and the number of the agents that you encountered. Any other identifying information is fantastic, but I don't know about you, but sometimes it can be really hard to remember things and to recall. It's part of why building that record, memorializing the things that happened to you are so critical. Because what it means is that then if you do seek legal counsel from people like me or other attorneys at the ACLU or EFF, those are records that were very freshly created in your mind and incredibly useful later down the line. Number 4 is an incredibly useful, but I will say, I always bring up number 4 around videotaping and recording with caution. Videotape and recording interactions with Border Patrol or other agents on private property is not against the law. But, and this is a really very big but, CBP prohibits recording anything on government property at ports of entry. And so it's a very careful dance. If you do want to record, you have to make sure, if you're recording anything, that that is not at a government property port of entry. Because if it is, that could be an additional reason for you to be pulled over, arrested, detained, whatever. At the same time, one other wrinkle in number 4 is thinking about where you are. Some states around the country require the consent of all parties to videotape or record people. Some do not. And it really depends by state. So I know that I looked into, for example, some of the issues in Washington state back when over 50 Muslim Americans and other Muslims were detained at an airport there. That was a really interesting case where part of what we were worried about is not only the profiling of certain writers based on their ethnicity, but we were worried that there were certain ways that agents were targeting people who were known for voicing some kind of criticism of the immigration system. And this happened several months ago. I believe it was in late January. It might have been in early February. And so what I looked into was, well, what are the laws in Washington? But part of what you have to be aware of is for wherever you are, whether it's in California, whether it is then perhaps in Arizona, there are other places where you might need consent of all parties to a video recording or even an audio recording. So maybe you think, oh, this is great. I can record border agents because I'm on private property. Well, not necessarily. You have to make sure that this is not government property, and you have to make sure you're in a state that does not mandate or, as a prerequisite to the recording, require consent of all parties. And then finally, if officers do seize any kind of property of yours, whether it's digital devices or otherwise, I would absolutely encourage you to learn and memorize this number that you want Customs Form 6051D. 6051D. 6051D is sort of like a receipt, if you will, and you're allowed to fill it out so that you can ideally get that property back one day. If one of the things that has been seized, for example, is a digital device, very often, at least in the Al-Assad case, some of the devices from those plaintiffs in the Massachusetts case were never returned to those plaintiffs. And so it kind of gets back to the recommendations around how you get ready for crossing in trying to minimize the devices you have and minimize the data, is know that if something does get confiscated, realistically, you may not get that property back. The reason to request a property receipt, what is it? It's 6051D. The reason to request it is in part to help build that record. Build the record of what it is that happened to you. And one of the ways is having something as sort of codified within a government form. So this is a form that there are sample forms that you can fill out, like you can pull those up, but I would absolutely, if this ever happens to you where something gets seized, request that receipt from officers. So I'm going to try to wrap up because I'm sensitive to time and that we may have questions. And I wanted to close by at least just telling you some of the other ways that we're trying to stay active on these issues. First of all, we are doing these trainings all the time, which means if you are interested, if you want me to come, or any of us at Penn do these trainings for different audiences, I would love to do that. So please reach out to me. And I have my email here. Another is supporting legislation. Penn America is really monitoring what the various standards are for searches at the border. And we've seen some promising legislation proposed by Senator Leahy. And that legislation is actually making its way through Congress, and we're supporting that, trying to help expand that the standard for searches at the border should not be based on individualized or reasonable suspicion, but that instead they need a higher standard, that border agents must be able to show probable cause standard instead of that lower individualized or reasonable suspicion. What else are we doing? We're also monitoring cases. You know, I get contacted regularly by journalists so that we can maybe tell their story, that we can participate in advocacy or even lead advocacy on their behalf to protect their free expression, their First Amendment, their Fourth Amendment rights. So please reach out to us if there are times where you're worried about a situation or you want to walk through how you conduct a threat assessment. And then finally is follow us, because I would love to hear from you guys. I would love to hear about your stories, what you're working on, if in crossing you encounter new and different types of situations. So with that, I would love to open it up for questions.
Is there a way to check if I am on the list of activists that was being collected? Is there a reason I might want to?
You know, I don't have any links pulled up in the slide deck here, but I would absolutely encourage, frankly, everyone to read these news stories that I mentioned. I would start with the LA Times story, and NPR had a story February of 2019 that really kind of was that watershed story around people being unable to enter back into the US. So that was the first story. And then the second one is the NBC San Diego story about the database that is being maintained and was being maintained. That has sensitive information of about, I think, 62 to 65 individuals. We do not know the names of all of those individuals. The reporters who had access to see the database, they were able to list some of the individuals that we know about who are included in the database. And they range from human rights lawyers to photojournalists to other journalists to even activists who are kind of like I started, you know, out there, they're on the front lines. They are in many ways dissenting voices that are expressing displeasure, dislike, and acting on those types of opinions against the administration. And so I would say it's incredibly hard to ascertain if any one of us is on that database. And I would presume that at this point, those numbers and the names are growing, but we do not have a way of knowing that. And the one good news is that recently, this past February, CBP is now going to be providing annual reports of some of their activities. And so that is, we have yet to see what the first report looks like of what their various searches look like at ports of entry, but it's sort of the first step in some accountability. Our partners at the Center for Democracy and Technology had a wonderful role to play in pushing for this new policy. The senator that I mentioned, Leahy, he also supported this, who is also sponsoring legislation to change the probable cause standard at the border for searches. But I would say start by reading about this and then honestly stay tuned, because at this point it's incredibly hard to know anything else.
If I don't consent to a search of my device, can the CBP revoke my visa or global entry card?
Well, in the moment, no, that cannot be revoked automatically. But those are the types of things where, you know, I alluded very briefly to, if you take certain actions as an individual who's crossing, there are any number of ways that agents may respond. They may respond by escalating physically. They may respond by escalating with verbal threats. That is absolutely the type of verbal threat that I would caution you to be aware of as one of the things, is sort of like the list of the menu of ways that agents may try to scare you into doing something, whether it is consenting, giving implicit consent, or to encourage you to sort of, you know, weaken your ability to say no in many ways. But there are larger, if we take a step back, there are other ways then that the status that we have may actually be implicated. And I would not, honestly, it pains me to think about the ways that people and their status are retaliated against. And I certainly have talked to reporters who are coming back and forth regularly, and they say, you know, frankly, at this point, because of my status, I've had to stop crossing regularly because I don't want to feel like there's any flag on, let's say, my passport, or there's a flag on any of my IDs. And so if you're worried about certain things, I would not be worried about global entry as much. But if there are things with your immigration or your citizenship status. Just be sensitive to that when you're conducting your threat assessment.
Since cameras don't have built-in passwords, if asked to show my photos, must I, especially within the 100-mile border zone?
That's a great question. We recently dealt with a case where a photojournalist was stopped at an airport, and they believed that he had sensitive and like criminal activity shown on his camera. So they kept his camera, and as a result, he didn't get it back for, I think, months it was. He did not consent to them looking at it, but they consented anyway. That was obviously within the 100-mile zone because it was a port of entry at an airport. That's a really interesting question that honestly, if there's no built-in security around that and the camera simply turns on and they're allowed to look at photographs, it's one of the ways you may consider actually removing images or putting things on a different device, maybe inserting things like into the cloud so that when you're crossing, you don't have to have any images on your camera itself. I don't know what the realities for the person asking, what the realities and intricacies are of, how much time you have between crossing, whether you can feel confident in transferring all of your files and images, but as much as possible, minimizing what they might have access to is generally the smartest move.
Why do I have to remember the Form 6150G? Why can't I just ask for a receipt?
You do not have to remember it if you can't. But sometimes I have personally found that it's better to be able to cite the number to make sure that you get the right form. Because a lot of times, just the sheer bureaucracy of things, you'll be given something that isn't an official receipt form because maybe there isn't any in that specific office or entry post. So I would just say know that number, know the numbers in your head because they're really useful. And as much as possible, even if it seems like an informal way of being able to show regularly in your dealings with law enforcement that sort of the boundaries of your rights and the boundaries of their authority, even if you are consenting to things. And if you're polite, which I always encourage people to be, it's just another way to help use and sort of build your own empowered ways of interacting with law enforcement.
With the COVID-19 pandemic, have border procedures changed? Are things more strict, or is it just for tourists?
In many ways, I don't know yet. I have not gotten a lot of reports from individuals crossing that are moving back and forth covering the situation at the border. So I don't know if they're subject to more or less retaliation. I do think that there has been this interesting and really powerful way that news media, as well as activists, whether they're lawyers or others, are actually shining a light on these issues around the surveillance and the privacy violations we're seeing conducted by Homeland Security and CBP. And so what's really interesting to me is in this moment, are we going to see now that CBP has to provide records and sort of a summary of its activities? Will we see in 1 year those search numbers, the 33,000, will we see that go down? If we're talking about people crossing and then being subject to other types of screenings, secondary screenings, digital device screenings, and searches, honestly, I'm not sure yet because it's been such a truncated and shortened time. The pandemic hit here, at least in the United States, not really in its full force until mid-March. And we're now almost in May. So it's been about 8 weeks. And I know that people are continuing to cross for work, but I haven't gotten many new reports. I'd be very curious to hear what you're experiencing. On the one other point I'll make, though, is that we know that Trump's order to halt immigration is something that does not mean people will stop crossing for work. And as that continues, as people continue doing their job, trying to tell stories, I'm also curious. I'm really wondering what will happen to those individuals. If there's going to be a heightened sense of retaliation to clamp down on stories from being promoted, because we know that happened during last summer's issues around detention centers, that reporters were aggressively denied access to detention centers around the United States because the stories there about the health conditions, about the basic human rights violations we were seeing, the administration just did not want those to be exposed. So I think we're going to have to wait and see. And as many stories as often as you're comfortable telling and coming forward about, those are instances that help inform our work, to be able to position it as a sort of civil society organization to say, this is absolutely appalling. And these are the ways that we want to shine a light on the problem and to try to empower people like all of you, so that when you do go out in the field, and you're coming back, crossing, whether it is going into Mexico or in the United States, that crossing borders is not something that fills all of you with the sense of fear. And it's an incredibly scary process. So many reporters I know are saying, I can't do it right now. It's been too much. I've been stopped too many times, and I have to cool it because it's too stressful. So I think we're going to just have to wait and see.
Do permanent residents have the same rights as citizens?
Well, knowing your rights is different than them being violated. Permanent residents absolutely have the same rights at the border as citizens, but that may not prevent someone from flagging your ID or flagging what your rights are and threatening to change status. That is really, truly one of the most powerful ways that agents can intimidate people who are crossing.
Are we entitled to ask and know the probable cause a CBP official may have against us?
You are absolutely allowed and should ask, what is the cause for my being detained? So if you think back, right, to one of the tips I said, agents should not be questioning you about things unrelated to verifying your status. They can know what your status is. And it does get back to the question around permanent residents or others. They will inquire. That is literally their job. And I do not want to demonize some agents who might actually be trying to conduct those types of questions. In the course of that, of course, there are going to be intense and extensive violations that may occur, but they may ask to verify your citizenship status. However, they cannot hold you for an extended time without some cause right behind that. Is it that they speculate you have committed or engaged in criminal activity? Is it that they speculate you are lying about your citizenship and immigration status? Whatever it is, you still absolutely are allowed to ask what the cause is for why you might be held. If you're being held, you can also ask, am I free to go? Because one of the hardest parts is that feeling of you have not been ordered to do something, but you do not feel free to go. If you do not feel free to go, if you are not free to go, then you can say, I presume I'm under arrest. Or what is the probable cause for my being held? And then you have the right, as I mentioned, to remain silent if they do not let you go. But you absolutely are entitled to ask the question, and you should be entitled to an answer. I think it really depends on every case and every agent what kind of answer you will get.
Have you heard of people being detained and harassed going into Mexico?
It's an interesting question because the first case that we heard about last February were cases of U.S. citizen activists and lawyers and reporters that were being held in Mexico after their work. So they went into Mexico for work or otherwise, to report on something, and then in trying to come back to the United States were denied access. And at the time, the early reports were speculated that Mexican officials had been asked by Interpol to flag people's passports. What's interesting then is that the later stories that developed really showed that US agents, that Homeland Security and CBP were really the arbiters of these sort of ad hoc policies, if you will, and the monitoring and surveillance of individuals for their work back and forth. So it's honestly become quite a strange mix of the issues that we're seeing where people are experiencing absolutely challenges coming back to the US, and there are a whole host of other human rights issues being faced in Mexico, which are apart from the issues that we're seeing of individuals retaliated against for whatever their storytelling, their reporting, or otherwise by US officials. Please follow me and stay tuned. Email me if you have questions, because I would love to hear about your stories.